Hello, beautiful humans. Welcome to my channel. Welcome to the Midlife Revolution. This isn't exactly a podcast, but here we are on the morning of, we hope, closing arguments for the Lori Vallow Daybell trial in Arizona. As you can probably tell, I am back in my home studio. I am so happy to be here and not in Phoenix, Arizona. I spent enough time in Phoenix. It was not fun. I did not enjoy it, quote unquote. I enjoyed the people that I got to be there with. I loved being able to reconnect with some people who were involved with Lori's first trial and with Chad's trial. I loved meeting some wonderful new people. I had a great reconnection with a lot of those people. Other than that, it was not fun to be there in the mix. And I think what I related to Susan Hendricks when I did my interview for her channel, which is Headline True Crime, I said I was not prepared for how it was going to affect me to be in proximity of evil for that long and to be totally immersed in listening to Lori and her garbage all day, every day for several days. So I'm very grateful to be back here at home. And this morning, speculations abound. Do we think that Lori is actually going to rest in front of the jury this morning? Or do we think that she's going to change her mind and try to testify? Now, we know Judge Boreski said previously, if she is going to testify, she has to let the court know in advance. She has to submit questions in advance. And so far as we know, that hasn't happened. Yep. Kid stuff. So happy to be here. My kids are off school today because of the Easter break. So we had a nice long weekend together, Friday and today. They've been off of school, and we had a lovely Easter. I hope those of you who celebrate had a lovely Easter. I just had a nice little brunch here with my kiddos. And for those of you who didn't know, my oldest daughter's second son was born on Friday. It was very unexpected for that to happen so quickly. So we're celebrating the birth of my second grandchild, as well as my daughter who's getting married a week from yesterday. So it is a busy time here at my house. And we are squeezing this in because justice for Charles is important and because the truth matters to me. So there are several different things on my mind over the weekend that I've been thinking about, things I want to talk about with you guys, theories that I would like to hear from you. And it sounds like from those who are commenting, people think that she is going to testify. Well, she can't really testify during her closing statement. Her closing statement, there are rules around that. And if she begins to testify, then Trina K can come in and object to that. She's not allowed to testify during her closing statement. So it'll be interesting to see. She left the door open on Thursday to say that, hey, I want to rest. And then Trina K said, you need to rest in front of the jury, which I think is important. And she said, the judge said, can you rest in front of the jury right now? We'll bring them back in. She said, can we wait till Monday? Well, that leaves the door open for her to possibly testify. She did go ahead on Thursday and dismiss anyone who had been subpoenaed. And for those of you who didn't see, on Friday, I did do a video with Joe Schmo and with Cresha Easton, who is Kay and Larry's daughter, Charles's niece, where we discussed all the subpoenas that Lori sent out to people that were not on her witness list. And among those, for those of you who didn't catch it, were Melanie Gibb. She subpoenaed Melanie Gibb, even though Melanie was not on her list. And of course, we know Larry Woodcock and Bobby Vallow. She tried to issue those subpoenas as well. And she claimed that it was a mistake. And she claimed she was just signing a stack of subpoenas and wasn't really paying attention to who it was. I don't think it was a mistake. Not at all, 100%. I think that she definitely did that on purpose. I don't think anything that Lori has done in this regard has been a mistake. I think she does it on purpose to just instigate drama and also to sort of poke at those people. Remember, she said that she was looking forward to facing all of the people who have lied about her in one of those interviews. And I think this is part of that, calling subpoenaing Melanie Gibb and Larry Woodcock, even though they have nothing to do with the trial. So yes, I am home all week long, getting ready for the wedding. My family is going to start coming in on Thursday. And so the whole weekend is going to be just wedding things. And I'm very, very excited for that. And then afterwards, I'll be able to head out to California to visit my brand new grandson. I'm very, very excited. So she's getting married a week from yesterday. So very excited. I will be posting some pictures over on my Patreon. I do have a free Lori Vallow Daybell chat over there, as well as a free Just Megan Connor chat. And that's where I'll be putting that kind of information, because I don't want it out here on the public YouTube channel. And then I will have some things for my paid Patreon members, some little extra nuggets, behind the scene things, and lots of extra bonus content on there. I've already posted several different cooking / videos in the kitchen, and as well as some little bonus nuggets from Janice's Instagram. So the couple of things that I want to talk about real quick before the stream starts in about 15 minutes. I have heard speculations all over the place from everyone about what might have happened in that Four Peaks residence on the 11th of July, 2019. Of course, Lori is the only one who was there who's still alive. So we're never going to know exactly what happened. And no, I will not be making any green chili enchiladas this week. Actually, maybe I will make the actual real green chili enchiladas, because the recipe I suspect that Lori's referring to comes from, long history of Mormon tradition, Mormon cookbooks. And they're ones that my mom and I actually used to make them when my kids were younger too. But now I know how to make real green chili enchiladas, so maybe we'll do that. Yes, I can drop a link to my Patreon. And as always, thanks everybody for being here. I appreciate you so much. And it is good to have so many beautiful humans who care so much about justice for Charles and who care so much about this case. It means the world to me that you're here. And it actually does help me process. It helps me to heal from all of this. And so I appreciate you being here. And I appreciate you guys adding so much to the discussion. So yes, we've heard so much about what potentially maybe might have happened that morning. And I've been reviewing Alex Cox's original police interview, the one where he's sitting on the curb. I think it's important to note what he said in the police station, but the one where he's sitting on the curb, I think, is the most important one, because it's the first one before he had time to sort of reframe things in his mind and rephrase things the way that he wanted to. So I've been looking at that one again today. I went back and looked at the diagram of the home that was shown, I believe, on day 2 of the trial. And I've gone through and I've enhanced that diagram a little bit so that we can see exactly what the house looks like. And I want to go through and I want to add a little figure of Alex and a little figure of Lori, a figure of Charles, a figure of the kids, so that we can sort of try to understand what actually did happen. And I want to look at Lori's story compared with Alex's story, compared with Tylee's story. And I really want to go into that because I think it's so important to figure out what actually happened. Now, the speculations that I've heard, things like Lori fired the second shot and, all kinds of other speculations. I want to talk about those, and I want to see if we can narrow it down and nail it down to, something that sounds the most plausible, that according to the evidence that we have, not according to, necessarily the statements or speculations of other people, but the actual evidence that we have. And I'm going to see if I can share this diagram real quick. I don't know if I can or not. Oh, okay. Let me see if I can do it, because I've been working on this morning in an effort to try and figure it out. So let me go back. And for some reason, my computer is running a little slow this morning, so that's not helping. Well, it doesn't look like I'm going to be able to get it up right now to share with you, but it's something that I've been thinking about. In addition, I want to tell you as well, when I was looking back at that video of that day in court, they briefly showed the back of Alex's truck where we were able to see his license plate. And I don't know how many of you have caught this. Apparently, there's been some discussion about it on Reddit, but I don't think we've talked about it here yet. How many of you guys have seen that? His license plate. It was so interesting to me. Let me see if I can show it to you. Well, my screen showing capabilities are not working at the moment, but they will be. And here's what I would like to do. So we think what's going to happen this morning is that I believe what's going to happen is that court is going to start at 10 a.m., which is just here in about 13 minutes. They will then make a final determination what's going to happen with Lori, because the judge always comes in and asks, do we have any matters that we need to go over? Sometimes motions will come in over the weekend. Sometimes they'll have an email exchange that they need to discuss. So I think that's what's going to happen first at 10 a.m. The jury is scheduled to come into the courtroom at 10:30, at which point we believe Lori will rest. If that's the case, they have already reviewed jury instructions. That's what happened last Thursday. And yes, you'll be watching right here. I'll be right here with you. I will show the live stream as soon as it comes on, right here from here. You don't even need to go to a different link. After Lori potentially rests, they will read instructions to the jury about the rule of law and what they should and should not consider in their deliberations. Then court will break for lunch for an hour. And after lunch, then there will be closing statements. First, Trina Kay will give a closing statement. Then Lori Daybell will give a closing statement. And then it's possible the state can have a rebuttal to the closing statement, I think. And so that's all that's going to happen in court today. After closing statements are over, I believe that the jury will be released to deliberate, and it's anyone's guess at that point how far it's going to go, how long they will take to come to a decision. A lot of experts estimate that for every week of trial, the jury needs about a day of deliberation. So in this case, it's possible that they could deliberate for a couple of days. We don't know, though. Sometimes it goes a lot faster than we think, and sometimes it goes a lot longer. So what I'm going to be doing is that I will stream as soon as court starts. I'm going to stream right from here. Following the stream, I will do a brief recap for those people who don't want to watch the whole thing. And then I will break for lunch. And after lunch, I will do an afternoon stream, which will have closing statements on it. Again, I will come on just a little bit before the stream starts. Hey, Irish Jen, thanks for being here. And I will have a little commentary after the stream ends. But I wanted to break it up into two because I know that some people, when they're looking for this later, if they don't catch it live, people are going to be looking for jury instructions and closing statements to be separately. So it's anybody's guess as far as how long the jury will deliberate, but we will have jury watch here on the channel together. I'll be here, right here with you. We can chat, we can talk, we can speculate. I can present some of the things that I've been thinking about and talking about over the last little while. So I definitely think it's up in the air as far as whether she's going to testify. I think she's going to hold it right down to the last minute because there are so many compelling reasons for Lori to testify, not legal reasons, not, whether it's smart enough, whether it's wise for her to testify. She's probably not taking much of that into consideration. She's thinking this is her last chance to get her narrative out there. The difficult side of that, though, is if she does it, she opens herself up to cross-examination, which means that they can bring in her prior convictions And you can bet Trina K is going to exploit that timeline to say, this was kind of the first in a long string of things that happened that were not good. And so, that's all she has to lose, essentially, is the jury knowing about her priors, which we've talked on this channel before. I think there's a dark part of her secretly wants that information to get out. So it's anybody's guess. And I do see that it's almost over, and I'm so, so grateful for that. But there is a little bit more digging to do. And I definitely want to get into the text messages that we read in court last week. There were a lot that were left out, and I want to read through all of those because I think it's so, so important. Hey, Debbie, konnichiwa to you as well. And welcome to anyone who is joining us live here this morning. Those of you who are joining on the replay, I'm so glad you're here. Thank you for being here, and thank you for taking the time to watch. So I agree with this, Pamela. It's all about her control over the process. She has, I think, wanted to definitely testify. She can't use her closing arguments to testify because if she starts doing that, again, you've heard Trina K object in the courtroom where Trina K says, objection, counsel is testifying or the defendant is testifying. She can't do that in her closing statement. There are very strict rules about what she's allowed to do. So yes, she's been vocal, and yes, she probably wants to tell her story, but she's been advised by her advisory council is probably not a good idea. And on Wednesday, when she rested, she read in a Rule 20 motion where she said she doesn't believe that the state has made their burden. And she doesn't have to put on any evidence. And the jury will be instructed by that too. They will say to the jury, the defendant does not have to put on any evidence and they don't have to testify. You can still find them not guilty if there's a reasonable doubt that she did commit this crime or she did engage in this conspiracy. And yes, I agree. MB, great to see you this morning. I hope you're having a wonderful day. Not testifying is another form of control. So lots of love to MB this day, this week, this month. She needs a little extra support. Just say hi to her and I hope you're doing well. It's great to see you here. So I've got a little cup of tea here with me, and I am ready. I am ready for court to begin. So I'm curious to know theories from you guys. I'll just put out a brief theory without going into everything that Alex said. But based on Adam's testimony, what Alex said to the police, and I do have to give credit to one of my subscribers who is in the medical field, went through the autopsy report and sent it to me with some extra notes attached to it. She noted that Charles's bladder was empty and that it indicated, because it was so completely empty, it indicated he might have gone to the restroom right before this happened. And when I looked at the crime scene photos and saw Charles's flip-flops were kicked off just at the base of that step down. So when you come into the house, there's a little step down. His flip-flops were right there in front of the step. I think that he probably came into the house, kicked off his flip-flops, set his phone down on the kitchen counter, and probably hit record, as Adam indicated, and then went into the bathroom that was just off the kitchen there, the little powder room, went to the restroom, and I think when he came out, he was ambushed by Alex. That's what I think. Now, that doesn't also give us any indication of what was going on with the kids and how they got out of the house. And gang unit, yes, it is a consideration to say that's possible too. But knowing that little nugget of the possibility that, he just came in casually, was like, hey, they're probably up to something, so I'm going to record this conversation, and then, went to the restroom. I think it's very likely that he could have come out of the restroom and been ambushed at that point. Anyway, this is a discussion that I want to have with you guys. I want to talk about it because it's what kind of has been going on over and over in my mind. And there's so many theories and speculations that I think a lot of people could benefit from talking this through and like, let's get all the theories out there and let's debunk the ones that don't seem likely so that we can move on to what we do think is the most likely thing. So I'm just putting that out there. And hey there, Latter Daily Digest. Thanks for being here. Colby is not actively LDS. He has not been in the church, I think probably for a long time, but he is a Christian. He does have a faith. And I think it would be great for everybody to go over and like his channel or subscribe to his channel, listen to him. He has lost more than anybody else in this entire case. And he definitely is in that inner circle of somebody who has been deeply, deeply affected. He lost, the only dad who was really a father figure to him, as well as both of his siblings and his mom, really. So I think it's been really, really hard on Colby more than just about anybody else, except for maybe Larry and Kay and Charles's family. So I hope people will go over there and listen to his channel and support him. He needs all the love and support that he can possibly get. So I'm grateful for all of those who support Colby. He's doing the best that he can to heal and using the tragedy to help others as well. Carolyn, we were talking about this earlier, that Melanie Gibb was subpoenaed by Lori. And she wasn't able to be served, of course, but I think it's interesting to note, Lori just kind of was subpoenaing everybody that she could to get back at them for whatever. And Irish Jen, I think Tylee was encouraged in advance to help protect using the bat. I agree with that. And that was the way Lori and Alex could put the bat in Charles's hand. I agree with that. And also the other little nugget that I want to bring in is that Lori kept wanting to bring in this video into evidence that Janice and Summer watched. And I think in her opening statements, Lori lined out all of these dates that Tylee had arguments with Charles. And I think on one of those dates, this argument was recorded. And I think that Lori showed a recording of an argument between Tylee and Charles to Janice and Summer. And I think Janice and Summer hyped it up and got upset about it and probably said to Tylee, you can defend yourself if you want to, and probably got her all agitated that, if you wake up in the morning and you hear arguing, you can absolutely defend yourself if you want to. So I want to bring that little piece of it into it as well to say, I know a lot of people said, Charles was ambushed and he couldn't possibly have had, there was no bat, there was no argument. I honestly think that there was, and I'll tell you why. And I've said this before. I think Tylee was coached, but I don't think that she would have made up the entire story about the bat. So right now it is 10:30 a.m. in Arizona. We're on a 30-minute delay. So I expect the live stream to be starting any moment now. And thanks so much for the congratulations, everybody. So that we should be starting with court any minute now. Court started at 10 a.m. Arizona time, which was 29 minutes ago. So the feed from the court TV camera should be coming to us any minute. And when it does, I absolutely will be starting it. And we're just waiting. It should be just any second now for it to come on. I'm going to continue to stream as the court is going on. I'm going to mute my microphone. I will come in if there is a break in the court, if they're having a sidebar or something like that. 3 hours. Ooh, goodness. Okay. Well, I'm going to have to, here's what I'm going to do. I'm going to start texting some people who have boots on the ground there, because if it says it's not starting for that, I don't think that's true. My court TV stream says starting at 12:30 p.m., which is right now. I just refreshed it. So as soon as court starts, now they were scheduled to come into court at 10 a.m. Usually they come in, the judge says, do we have anything before the court? He'll probably ask Lori, is it still your plan to rest today? And then they'll bring the jury in at 10:30. So that's kind of what that's kind of what we're looking at here. So I'm going to real quick text my buddy Joe Schmo, who is in the courtroom, and see if he can tell us what's going on. Are you in court? What's happening? And then another thing I can do, Justine says, and I think this is important, I'm wondering if Tylee admitted something to Janice that day. As Adam reported, when he saw Tylee at his parents' house, Tylee was crying and visibly upset, unlike at the site. Yeah, I think that's definitely possible for sure, because if she was that upset and Janice was trying to kind of keep Tylee away from Adam and didn't want them to talk, yeah, I think that that's problematic, and I think it's possible that Tylee did admit something today. So the schedule for court today, and I was listening, there will be a 5-minute delay for closing statements, and there will be a 5-minute delay for the verdict, not for closing statements. So Joe Schmo is in the courtroom. He says it is a packed house this morning. You're right. 5-minute delays for the verdict only. So according to what they said in court on Thursday, which was the last time that they met, court convenes at 10 a.m. Jury gets brought in at 10:30. If Lori's going to rest, she'll do it then, followed by jury instructions, followed by lunch, and then closing statements begin at 1 p.m. That is what has happened. Oh goodness. Joe Schmo says 6 ladies just walked in and sat down in the family section behind Lori. Curious to know who those might be. I'm also going to go over to Justin Lum's Twitter and see if he will tell us what's going on. So very curious to know who those ladies are. Obviously can't take pictures, but there was one point where Joe Schmo asked me to look at a woman in the courtroom and say, who is that person sitting behind Lori? And it was not somebody that I recognized. So it's easy to just look over there and be like, nope, that's not a family member. But for him to be in there and have to sort of describe what's going on, goodness. I'm looking at Justin Lum. Here we go. Court is about to go in session in moments. We also need to see if Lori Vallow Daybell officially rests her case in front of the jury. The jury reports at 11. So yes, I guess it'll be another 30 minutes before the jury is there. Joe Schmo says they may just be members of the public that security lets sit there because nobody ever does for the most part. And that's true. They've got a couple of rows in the back of the courtroom that are reserved for media. And then they sort of let the public filter in. I'm looking at a picture, and I'm going to go ahead and share this with you. It looks like a long line of people waiting in front of court this morning. According to Justin Lum's Twitter. And so, yeah, it does say they added 1 folding chair to the end of all the rows. So 10 extra seats, 8 for the public, because it's so crowded in the courtroom this morning. So, yeah, I guess the live feed will not start until I know we're on a 30-minute delay. It was my understanding that jury was coming in at 10:30. I'm going to double check with Joe. By the way, if you haven't liked Joe Schmo's channel, his channel is Joe Schmo 88. I don't know, Jen, if you have the link, if you can put it there. Joe Schmo has been helping me out with the investigative side of this. He has done a really, really great job going through these motions with me, and I've appreciated his help so much. And so if you would go over and like his channel, I would really appreciate it. He's Joe Schmo 88 here on YouTube. There's the link right there. So we're just trying to figure out what time live stream is starting here, because they are clearly in court, on the record at 10:30 with the jury in. So no, definitely it's a real channel. So the confusion is that court convened at 10 a.m. this morning. We're on a 30-minute delay. Just because the jury is not there doesn't necessarily mean that we won't get some of the feed, especially if they're on the record. We've gotten some of that feed in the past, but also I'm used to sitting there in the courtroom and being able to hear everything that goes on before the feed starts. So that's where the confusion is this morning. So I'm just coming over to, again, Justin Lum's Twitter to see what updates that he has. I showed you guys that picture of the line in front of the courthouse. Okay, here we go, you guys. Some court housekeeping as we get ready for the jury to hear instructions. Both defense and prosecution have gone over the instructions and have no issues. Lori Vallow Daybell confirmed she intends to rest the case in front of the jury. Here we go.
And the defendant?
Lori Daybell.
All right, we met on Thursday and went over jury instructions. In the meantime, since Thursday, there was a few modifications sent out. We put drafts on your desk this morning. Last week, let me just pull up that email. No, you email. Last week, the state requested some modifications that were made, and then on Friday, Advisory Council also requested a correction to the presumption of innocence, which I did do, as well as a mere presence instruction. Does anyone want to make a record on any of those changes that have occurred since we met Thursday? I forgot, I don't know if my staff told you, I did add, I realized standard number 9 was not added, which is defendant need not produce evidence. So I added that this morning as well. Have you had a chance to review the latest draft, or do you need more time? We told the jurors to be here at 11, so we have time if you need more time.
The court sound is muted right now. Right now, they're just going back over jury instructions, reading through just to make sure that it is what they agreed to on Thursday.
Any other record you want to make on mere presence? All right, has the defendant had a chance to review the final instructions?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning, well, let me ask the defendant, you still plan on resting?
I do.
Okay, so when the jury comes in, I'll remind them that the state rested last Wednesday, and then I'll turn to you and you'll presumably say the defense rests. I'll read the jury instructions and we will break after I read the jury instructions. Depending on what time we break, I'll tell them what time to come back for the closing arguments, approximately an hour later, or around 1 p.m. While we're waiting, I had my staff email the parties about any potential aggravators. I didn't see a response to that. So in addition to, if there is a second phase of this trial for aggravation, in addition to a dangerous finding, does the state know what other aggravators it might be pursuing?
Potentially the emotional harm.
Anything else?
The presence of an accomplice.
Okay.
That should be it.
And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Potentially testimony from Mexican.
Okay. All right. So how many jurors? You can go ahead and print out.
Your Honor, I have two issues I'd like to bring up real quick.
Go ahead.
The jury process of the jury alternate selection. Can you tell me what that process is going to be today?
It's literally drawing two numbers out of randomly out of a container.
Okay. And when is that going to be done and how does that
Not
work?
till after the closing arguments.
Okay.
So the alternates are told that they're still alternates, they're not released, because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me what's 286 is, whose interview?
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
So is it just the snippets that were played all together?
It should just be the parts that were played in court. Is that correct?
Yes, I mean, they're all connected.
All right.
The state redacted out the beginning, the end discussions of highly, that would be hearsay or not.
Right. So did you have a question about that?
Yes. So is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in court that are put together as one exhibit.
There's connectors in all of it, but it does not include any of the beginning or the end of the interview.
Right, portions have been redacted out. But it's just more or less what was played in during testimony.
Correct.
Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she's testified that it was the full interview?
I don't know. It's something you could have cross-examined her on, but now it's probably too late. If you wanted clarification on that, but the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the instructions. So either side can point that out to the jury that it's redacted. Anything else?
I was just assuming that that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into, to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the
Well,
exact
my advisory
testimony.
counsel checked the FTR, and that's exactly what was said. That was exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was
So-
there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
Was not for appellate purposes.
Okay.
Full interview, the defendant talks to the detective in the beginning about Kylie, does not include that. She talks to the detective at the end about Kylie and victim services. It doesn't include any of that. She's sitting in a room for I don't know how long while Kylie's being interviewed. It doesn't include any of that. It is her interview about what happened.
Okay. So the states closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Ty Lee said or did or didn't happen, the hearsay parts were the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
So we have
There.
our exhibit 20, the defense's proposed exhibit 20 is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No,
Why not?
your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that. Anything else?
That's it.
All right, we're getting the sufficient number of the jury instructions copied. As soon as that's done and our jurors get here, we'll read those instructions. All right.
Okay, so I'm just going to come on here to comment while we're waiting. So the jury's not going to come back in for another 10 minutes or so. And so just to recap the salient points for those of you just getting here, that the deal is here that Lori is going to go ahead and rest her case. And then they were going over the jury instructions that were agreed to last Thursday. And at that point, they asked if there were any other matters that needed to come up. And Lori said, she wanted to ask about how the jury gets picked. So we have two alternates. And the way that it works is that only 12 jurors will actually get to deliberate, and the other two will be dismissed. And we know this from the last two trials, from her first trial, from Chad Daybell's trial. We know that the alternates get dismissed prior to deliberation, and what they do is they literally just draw numbers to see which ones get dismissed. So it's a random process, and Lori should know this from her first trial. She's had that extensive trial experience she keeps talking about, but she didn't understand that. So it's literally just they're going to draw numbers, and then the 2 numbers that they draw get dismissed from the jury pool. The other 12 go in and deliberate. And then this most recent argument, Lori said it has been brought to her attention that the exhibit, she names the exhibit number, was not admitted in its entirety. And so she's having trouble with this. Well, the thing is, she actually objected to the entire interview not being admitted. She knew that it was a partial interview. She knew that it had been redacted. And the reason for that is because a lot of what she said in that interview is considered hearsay and can't be admissible in court. So I'm guessing that Trina Kay, being the competent prosecutor that she did, probably redacted the interview down to what is admissible in court. And even then, the prosecutor only asked Detective Inclan certain questions about that video. So yes, only portions of it got in. So, she knew it was redacted. She objected to it in pretrial hearings before. She objected to it in court when it was played in court. She said, the only objection is that it's not the full video. So she knows it's not the full video. But this is a classic example of someone with narcissistic traits trying to reopen an argument that has already been settled, coming at it from a different tactic, because now she's thinking to herself, she really wants this full interview in. That's what she's wanted the whole time. She wants the jury to hear her whole story, but she doesn't realize, probably because she hasn't reviewed the video, that the redacted version doesn't contain her retelling of the events of what Charles said, of what Tylee said, of what Alex said, because that is all hearsay and it can't come in. So I think in Lori's mind, she hasn't considered the fact that the parts that were redacted are the very parts that she would have wanted to have come into evidence. She wants the narrative to come in that Charles was the aggressor. And so those things probably have been redacted from this version of the video that the prosecutor showed in the courtroom. So again, we've already settled this argument. Lori doesn't have a leg to stand on. She already knew that it was a redacted version of this interview, and she's trying to reopen the argument because she wants the jury to be able to see the full thing. Well, the other thing she doesn't realize, let's say that the redacted version is 25 minutes long. She thinks that the jury can watch all 25 minutes of that. They can't. All they can watch is the portions that were played in court that the detective on the stand was testifying to. So she doesn't realize that the jurors can't watch the full video anyway. They can't watch the 25-minute video. They can't watch the full video of her interview unredacted. I think the problem here that we're finding, Irish Jen, is that the court doesn't speak Lori. And they're assuming that she is a reasonably intelligent person who's educated somewhat on the law because she has presented herself as such. She said she's been studying in prison. And so you can only watch, this is right, Lisa, you can only watch the exhibits admitted, and you can only watch the portion of the exhibit that was played in court because that is what the detective was testifying to in court. So the jury can't even watch the full video. They can only watch the portions that were played in court. So, yeah, I think this is a thank you so much, Robin, for showing up. I appreciate you. She can't understand. No, that is true. Sit Down Blue says, my theory is that she was there when he got shot because she was trying to prove that the sequence of events that the police were saying was not true, but couldn't tell them she was there and watched it. That is a good point. It's very possible. And there was a little bit of hot mic. Lori has gotten better at muting her mic. Darn it. And so right now we're just waiting for the jury to come in. They should be here in just a couple of minutes. So yes, again, it's her version of what happened. I did get to visit with Kresha on Friday a little bit. She seemed to be doing okay. We hadn't gotten to talk throughout the whole trial, but she seems like she's doing well, and I'm glad she's at home with her people around her. I think Crafty Chris, this is probably true. Never heard no from her family growing up, so she doesn't understand why now. Somebody asked at one point, let me read this first. The problem, Dog Mom says, the problem is that Lori will never accept the word no because she thinks that if she bats her eyes and her little giggle, that everybody will be so stunned by her, they'll just say yes. That is what has worked for her in the past. Unfortunately, I pointed out before the trial started, she's going to find out very quickly she can't do that in court. She can't manipulate. She can't lie. She can't, make these arguments that have no legal basis. She was so used to being able to manipulate the conversation in the way that she wanted to, and she can't do that anymore. And that's why she's so frustrated with all of this. I want to answer this question that got started before we started here. Gina Ross asked, were any of your siblings also close with Lori's family growing up? And did any of them maintain relationships with her once they grew up? I will say, I believe probably my older brother is still in touch with that part of the family very much. And I think that's pretty much it. My younger siblings, I know, have talked back and forth with those cousins, but weren't necessarily as close. They were younger, obviously, when my brother and I, as teenagers, were visiting with the Coxes and everything. They were in San Antonio when the Coxes lived in San Antonio. They were going to those family gatherings and everything. But by that time, the older cousins had scattered kind of into their own places of living. And so my younger siblings didn't really know the older siblings as well. Letter Daily Digest asked, could some of her closing arguments include her testimony in the redacted parts? Well, in her closing argument, she's not allowed to testify, meaning she can't bring in any more ideas or quote unquote evidence that haven't already been reviewed. All you can do in your closing argument is review and emphasize the evidence that has already brought in. Irish Jen says, where does your extended family sit on feelings for this situation? Honestly, I haven't talked with as I said, I talked with Adam and Rex there right before they went into court that day, and talked with Rex's daughters that morning, and haven't really talked to anybody else in the family about any of this since then. I did let my sister know, that I was there in court, and we talked just very briefly, just for literally a second, about it because we were more focused on talking about my new grandbaby. So. So no, we haven't talked about it yet. I imagine we will talk a little bit about it this weekend when we're all together. But Renee asked, were Lori's fingerprints on the gun? No, there were not any fingerprints recovered from the gun. And yes, I think to a certain degree, her closing does need to be reviewed. The state and the defense get to exchange each other's closing arguments and see it. And so I think the judge probably reviews it as well. And it cannot go outside of the scope of what the state presents and what she presented as, which she didn't present any evidence. So I'm going to go now I have to go back to this tab and refresh because it looks like, are we doing a new video? Okay. So they've set that video to private. That's interesting. I hope I didn't do anything I was not supposed to do. So let me go back over to their channel and see what's going on.
And I prayed to God, please don't let it happen.
How can we believe you? On the next Interview with a Killer.
I don't like it when stuff plays automatically. Okay, so probably what's happening is that Court TV is going back through, and the reason it's on a delay,
and I prayed to God, please,
is because they're supposed to be able to edit things out if need be prior to that happening. So right now, what I see on the Court TV feed is that the live that we just watched is not available. And there's also not a waiting room available for the next portion, which is supposed to start right now, actually. So let me see what's going on. I'm going to text my people in the courtroom. And we'll see what is going on. I'm also going to check in with the Twitter feed here. And see what Justin Lum is saying. Okay, he just says that we're waiting for the jurors to report. So I think we're fine. I'm just going to go back and look at the court TV feed and see if they've set up their live or not. And they have not. So let me go to a couple of other channels and see what else is going on as well. Yeah, I know that we're on a delay, and the jury is coming in at this moment, but they're on a delay, actually. So that means if they're on a delay, if the jury is just now coming in, then there should be a delay. So we're looking for day 9. Okay, so Joe Schmo is reporting the jury came in at exactly 11, which was 3 minutes ago, and Lori rested the defense. So I'm going to go to a different feed now and see if we can get it live. Okay, well, right now, what East Idaho News is playing right now is what we already played. So I think that it is possible that Court TV did not have their delay on properly. It was my understanding that court started at 10 this morning, which is the same time that I started this live. And so that means that at 10:30 is when we were supposed to get the live. So I think what happened is that Court TV did show, I think they did do it on a 30-minute delay. And yeah, exactly. They're showing what we just already watched. So I think they did do a 30-minute delay. I think Court TV did it right, because the 5-minute delay change is only for the verdict. It is not for this part. So at 10 o'clock this morning, that's when court started. At 10:30 Arizona time, Court TV started the feed, and that's when I started it too. So I don't think we did anything wrong. I don't think Court TV did anything wrong. But now the jury is in the courtroom, and Court TV feed will start back up here in about 25 minutes because they are on that delay. So I think we're all good. We didn't do anything wrong. Court TV didn't do anything wrong. It's just that the delay and the time change and all of that kind of stuff is confusing for everyone. So I guess here's my question. Should we continue the feed and wait here together for about 25 minutes? We can chat and answer some questions. Or should I start over when the jury comes in? I'm thinking I could just use this as like the morning prior to jury coming in, and then I could start again in 25 minutes with a different feed with Lori resting. So what do you think? Should we wait together, or should I start a new feed? I am going to start a new feed for closing arguments. And maybe what I'll do is we'll stay here, we'll hang together. And then after it's all over, I will cut Lori resting into a different video. I'll just separate them afterwards. So if you need a snack, if you need a break, go ahead and do that. I'm going to keep refreshing. And what I'm going to do is what I did with the hearing, with all the hearings that happened when I wasn't in Arizona, is that I just read through Justin Lum's Twitter feed so that we could keep up with what was going on in the court. And then we watched it live together. So I think that's what we'll continue to do here. In the meantime, I'm going to see if I can fix my screen sharing so that I can show you the diagram. Okay, so Justin Lum is going through reading the jury instructions, but he did not report that Lori rested, but we have that from Joe Schmo. So we know it's official now. Lori has officially rested. And hey, Lauren from Connecticut, I miss being in Connecticut. Okay, so we've got it from Joe Schmo. The jury came in at exactly 11 and Lori rested the defense. So that is real. We know that happened. Okay, now I'm going to go back over to my I was working this morning on my diagram of the house, and I want to see if I can share it with you guys. And also to share, oh goodness, it's all messed up. Also to see that if I can share my picture of Alex's truck so we can talk about his license plate a little bit. It seems like I have, as usual, too many windows open at the same time. And I think that's what's causing the problem here. So I'm going to close some of these tabs and see what I can do. All right. Oop, and that's the wrong tab. And okay. Okay, so yeah, so we haven't seen the jury come in yet, but the jury did come in. It is 11:08 Arizona time. The jury came in at 11 a.m. And Joe Schmo, who is in the courtroom, whose channel is Joe Schmo 88, I've had him on as a guest a couple of times. He has reported to me that the jury came in and she immediately rested. Now, we won't see that for another 20 minutes because of the delay. So it is, again, we're just on a delay. Okay, so there's a 30-minute delay because the judge ordered the pool camera at Court TV to be on a delay because just in case something inadvertently got broadcasted, they don't want anything about the jury to be broadcasted. They don't want the jury's faces, obviously. There's also a delay because they have redacted some of the more graphic pictures and videos that we've seen. And so that's why it's on a 30-minute delay. It gives Court TV a chance to edit out anything that should not have been shown on the feed. And so that's the reason why. And it should be starting back up again here in about 20 minutes. In the meantime, I'm going to try to get myself together to show you the floor plan of the house so that we can look at things in a little bit easier way, just to say, this is what it looked like, and is it likely that the scenario that Alex put forward or the scenario that Lori put forward, if any of those are going to be, if they're likely. I am having a hard time with my sharing stuff. Oh, here it goes. Okay. I think I found it. Nope, that's not it either. And that's why I wanted to do this like on a separate video, because I don't want to waste your time looking for things when I could be just over here answering questions. So just looking back through here for questions a little bit. And so we do have some pictures of the rest of the house. It is on day 2. And actually I could just show the video, because that's what I was looking at this morning anyway. Just looking for that. So we went over this in my day 2 recap, looking at the house and the lack of furniture and everything that was in there. But what we did see, which was interesting, is that Lori's room was fully furnished, and she had pictures of the temple on the wall. So I'm going to share now this tab, which is this is not today's video. This is video that was shown on day 2 of the trial. And I'm going to fast forward to here where we see the layout of the house.
We understand.
And I'm going to go just a little bit farther. Here we go. So here's the layout of the house. And if you look at the left of the screen is north. And this part of the house, the far right of the screen is south. And what I have in my diagram is labels of all of these rooms. So the room that my face is over, that's Lori's room. And you can see just on the bottom of the screen, there's a small powder room right here. This is an office area. And then this is the entryway right here as you come in the house. Now, this was where there were mirrors here on this wall. There were mirrors here on this wall. I believe there were even mirrors here on this wall. And this is when they're talking about going around the kitchen, this is what they're talking about. The kitchen is right here. You can see the sink area. And then this is the hallway that Alex referenced when he went back down the hallway to get his gun. Now, this right here, I believe, is the pink bedroom. And then this one that is off screen, we can't really see, is the blue bedroom. So when we look at it this way, to have Lori said, when you go back to Lori's testimony, she says that she heard the shot but didn't see it. So what she said was, I went around the island, and then ostensibly what happened is that she was here when the shot was fired, and then she came out here, went into mom mode, and exited out the front door to go take JJ to school. Whenever you look at the possibility of Tylee coming back into the house to get Lori's purse, so the garage was here. Tylee said she went back in through the garage, so she would have come in here and gone straight here to get Lori's purse and then come straight back out. I think it's pretty unreasonable to think that she didn't look around as she was coming in and coming back out. I believe that she probably did see Charles laying on the floor. I think that is horrible and traumatic for Lori to have done that to her. So anyway, I want to go back with all of yes, and Lori did have mirrors there in the house, and she was sending videos to Chad of her dancing in front of these mirrors. Kind of glad none of those came into evidence. Didn't really want to see that. So I'm going to just speed through here to see, because this was the day that we got to see other pictures of the home. This is where I noticed Alex's truck has the license plate CP Quint. Now, there was some Reddit discussion about what this might possibly have meant. And sorry, Joe Schmo is Joe Schmo 88. His channel is a little hard to find, but if you put Joe Schmo 88, you should be able to find it. We also had it. We had the link here earlier in the chat. Yeah, those they were dance mirrors. She did hang them in a rental. I don't know if they were glued to the wall or if they had those little tiny brackets at the top. So the discussion about Alex's truck, his license plate, CP Quint, on Reddit, thanks for doing that, Irish Jen. On Reddit, there was a suggestion that this is a reference to the movie Jaws. If you'll remember, the man who helped them catch the shark or kill the shark or whatever, his name was Quint, Captain Quint. And I know that Alex loved that movie. He used to quote it a lot. He would quote that monologue that Captain Quint did and his toasts of, "Here's to swimming with bald-legged women." That was what he always thought was really funny. But if we want to go along with the idea that Captain Quint is who he was emulating, let's think about who Captain Quint was. He was a shark hunter. He killed sharks. It's just interesting to think about that possibility. Okay, so I'm going back to Court TV now. I think we still have about 10 minutes before we're going to get the feed, but I just want to look. So yes, at least here we are. We can at least see that the feed is up and ready to go. They had taken it down before. So I'll go ahead and share it. They did stop the feed earlier, and I'm not sure why, but in any case, here it is. So yeah, just talking about CP Quint being the role model for Alex. I think it's kind of interesting. So we're all the way up against the live feed here for Court TV, and there is no jury back yet. So I'm even going to put it here. I'm going to put it on 2x because it'll catch us all the way up, and then it'll be normal speed when it comes back on. So I don't know if any of you guys remember the Jaws movie. It was one of my favorites growing up. And I remember the monologue that Captain Quint does where he talks about the USS Arizona going down in the Pacific and what happened with that. And it was very traumatic for me when I first watched that. But according to the people who are actually on the Arizona, if you do some dive into the history and the research on that, it's pretty accurate to what actually happened. That monologue that Quint does in the movie Jaws is pretty accurate to what actually happened to the survivors of the USS Arizona when it sunk in the South Pacific. So the fact that Alex is emulating Quint, the shark hunter, I don't know, I think is kind of interesting to think about. A sound-minded Cox was Alex of sound, not of sound mind. I don't think so. When you look at the body cam footage, when Alex is coming, so he's sitting there on the curb and he's giving a description of what happened in the house. Never once does he say that he is scared for his life, which to meet the burden for self-defense in the state of Arizona, you have to have feared for your life and also not been able to escape the situation. So the cop asks him, did you ever just think about going back to the room and just staying there and not getting your gun? No, never thought of that. Well, did you think about just leaving the house? His sister was gone. His niece and nephew were gone. He never thought about just leaving the house. Oh, you're so right. I'm so sorry, you guys. Yeah, I was thinking the Arizona because I visited it in Pearl Harbor when it sunk there. So yes, the Arizona was Pearl Harbor. It was the Indianapolis that was sunk in the South Pacific. Constance says, I treated a survivor of the Arizona in hospice care about 15 to 20 years ago. Hospice staff was confused why he was handling his difficult situation until they heard about this part of his past. Yeah. So the Arizona was in Pearl Harbor. Sorry, I've got Arizona on the mind. Obviously, the Indianapolis was the one that was in the Pacific. But yeah, so, Alex sitting there on the curb saying that he never thought about just leaving the house. He never thought about just staying in the room. And he also never said once that he feared for his life. He never talked about being afraid. He never talked about the bat hurting him, hit me in the head with a bat. And he never said it really hurt, or I was really scared, or I was jarred, or I was jolted. He didn't say anything about any kind of emotion that he felt, which is one of the things that I always thought was super odd about Alex, is that he didn't really ever show or express any kind of emotion. Somebody asked me once if Lori ever expressed like sadness or fear. I've never seen that in Lori. Now, of course, I wasn't with her all the time, but when I was interacting with Lori, everything was fine. Everything was wonderful. Things were not ever sad or hard or difficult. There was never a problem. So Alex not expressing any emotion whatsoever after just shooting his brother-in-law that he'd known for 15 years. It shows a couple of things to me. One, I think that Lori definitely alienated the family against Charles. I think she said, Charles is awful. He's a horrible person. He's a zombie. He's cheating on me. He's having an affair. Don't talk to him. Excuse me one second. I need to drink my tea so my throat doesn't get sore. And so I think this shows Alex unemotional towards the brother-in-law that he knew for 15 years, says, I've already detached. Like I have no emotion for my brother-in-law. I already believe that he's a horrible person. And so I think we've seen that detachment, right? In a person that kind of already knows their relationship is over. We've seen this before in people who are getting divorced, where they're like, I've already made the decision to get divorced. And so the next couple of weeks that we were living in the same house, I just didn't have any emotion because I'd already made that decision. So I really think that Alex had already dissociated from his relationship with Charles, number one. Number two, he shot his brother-in-law. He believed it was a zombie. I think we saw a text in the Daybell trial with Zulema, where Zulema says to, or maybe it was in the interview that Zulema did, the police interview, where she said, do you feel bad about, killing Charles? And he said he was a zombie. So no, I didn't, Alex never said, no, I didn't feel bad about it. He said, well, he was a zombie. And the conclusion that we're supposed to come to is that it's a good thing that he's dead, because it's a good thing that I killed him because he was a zombie. It wasn't Charles. The thing that stuns me is that there was never any grief expressed at the moment that they found out that Charles was a zombie, or at the moment that they found out that the kids were dark. There was never a moment of grief where Lori went in tears saying, I can't believe that my children are gone. Their bodies have been possessed, because what they believed is that their spirits were already in heaven. She said this about Zach as well. We saw that come out in text messages, that Zach is already gone. There's no grief for the person who's gone. There's only focusing on getting the zombie out. So that's what's confusing to me. It's just, again, this stunning lack of emotionality from Alex, his lack of ability to make human connections, his lack of ability to feel or express emotion in, what arguably is, for most people, would have been the most traumatic time of their life. Now, we also know that Alex tased Joe Ryan, so he's already completed an assault on one of Lori's romantic partners. And so for him, this is just routine. Just, again, got to do the same thing I did before. And so that's what's stunning to me is about Alex's lack of emotionality. He never says he's afraid. He never says that he fears for his life. He never talks about being hurt when the bat hits him. And to me, that's the salient point. That's what I would have, as an investigator, wanted to go back and talk about. Was, at any time, were you afraid for your life? At any time, did you feel like, if I don't shoot him, I'm going to die? So, I do have the stream going. I've got it up here. It's not showing the jury has arrived yet. So I definitely have it refreshed, and I have it all the way to the end of the bar over here. So it's weird because I think some of the other channels like Hidden True Crime are getting this same feed from Court TV, and that's where I'm at. So, if we're a little bit behind, that is okay. That's interesting. Let me go over. I know that Joe Schmo is there in the courtroom, and he is doing double duty, trying to report to his audience as well. I am showing True Crime has it going, so it's weird that Court TV does not. So that's what we'll do. We'll just go on over to Hidden True Crime. Okay. Okay.
The defense also rests, Your Honor.
All right, at this time, that concludes the evidence portion of the trial. I'm going to have my staff hand out to the jury the final jury instructions. Are we one? Oh, nope, we got it. Okay. Jurors have the instructions. Much like the preliminary instructions, you can either follow along with me or just listen. I need to read these into the record. Duty of jury. It is your duty as a juror to decide the case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. Evidence to be considered. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Rulings of the court. Admission of evidence in court is governed by rules of law. I have applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Redacted exhibits. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Indictment is not evidence. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think a defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. Self-represented defendant. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you when determining the facts. Comments are not evidence. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says or part of it or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Testimony of law enforcement officers. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Defendant need not produce evidence. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce evidence is not evidence of guilt. Defendant need not testify. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. Mere presence. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Voluntariness of defendant's statements. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. Jury not to consider penalty. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. Presumption of innocence, burden of proof. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. Evidence of any kind. The state must prove guilt beyond a reasonable doubt on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce evidence is left to the defendant. The defendant's decision not to produce any evidence is not evidence of guilt. Voluntary act. Before you may convict the defendant of the charged crime, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. The charged offense. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about July 11, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew he or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. Elements of conspiracy. The crime of conspiracy to commit first-degree murder requires proof. 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. Scope of proof of conspiracy. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. Proof of membership in conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or another person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists in the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Justification for self-defense physical force. A person is justified in using or threatening deadly physical force in self-defense if the following two conditions existed. 1, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and 2, the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A person may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use, attempted use, threatened use, apparent attempted use, apparent threatened use of unlawful deadly physical force. You must measure the person's belief against what a reasonable person in the situation would have believed. A person has no duty to retreat before threatening or using deadly physical force in self-defense if the person, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in any unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. If evidence was presented that raised this justification defense for count 1, conspiracy to commit first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the defendant or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Justification for defense of a third person. A person is justified in using or threatening physical force in defense of a third person if the following two conditions existed. 1, a reasonable person in the situation would have believed that physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, and 2, The defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect against another's use, attempted use, apparent attempted use, threatened use of deadly physical force. Defense of a third person justifies the use of or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that, 1, physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, or 2, deadly physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. You must measure the person's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Use of force in crime prevention. A person was justified in threatening or using physical force and or deadly physical force against another if and to the extent the person reasonably believed that physical force or deadly physical force was immediately necessary to prevent another from committing or apparently committing the crime of aggravated assault. There is no duty to retreat before threatening or using deadly physical force. There is no requirement that any threat to the person's safety exists before the person may use physical force and or deadly physical force. However, physical force and or deadly physical force can be used only to the extent it appears reasonably and immediately necessary to prevent commission of the crime of aggravated assault. The person's use or threatened use of physical or deadly force is not limited to a person's home, residence, place of business, land the person owns or leases, or conveyance of any kind, but includes any place in this state where a person has a right to be. The person is presumed to have acted reasonably if the defendant reasonably believed he or she was acting to prevent the imminent or actual commission of aggravated assault. The person is justified in using physical force and or deadly physical force against another person, even if that person is not actually committing or attempting to commit the crime, if the person reasonably believed he or she was preventing the commission of the crime. Actual danger is not necessary to justify the use of physical force or deadly physical force in crime prevention. If evidence was presented that raised this justification defense for first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Non-justification for threat or use of physical force. A person is not justified in using or threatening physical force against another in response to verbal provocation alone, or if the defendant or co-conspirator provoked the other person's use or attempted use of unlawful physical force, unless 1, the defendant or co-conspirator withdrew from the encounter or clearly communicated to the other person the intent to withdraw with the reasonable belief that the defendant could not safely withdraw, and 2, the other person continued or attempted to use unlawful physical force against the defendant or co-conspirator. The state has the burden of proving beyond a reasonable doubt that the defendant and or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Definitions. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Act means a bodily movement. Aggravated assault means a person intentionally, knowingly, or recklessly caused a physical injury to another person, or intentionally put another person in reasonable apprehension of imminent physical injury by either 1, causing serious physical injury to another person, or 2, using a deadly weapon or dangerous instrument. Conduct means an act or omission and its accompanying culpable mental state. Deadly weapon means anything designed for lethal use, including a firearm. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under the circumstances in which it is used, attempted to be used, or threatened to be used. Deadly physical force means either 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law, or where the context so requires, not permitted by law. Jury foreperson. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. Closing instruction. In a few minutes, we're probably going to take a lunch break, and then after the lunch break, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole reach a verdict or have been discharged, During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. All 12 of you must agree on the verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows, and there is no significance to the order in which the options of guilty or not guilty are listed on the verdict form. So this is a sample verdict form at the end of your instructions. It indicates this is a sample. An official verdict form will be given to you by the courtroom assistant in the jury room. Verdict: count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Lori Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about July 11, 2019 as follows. Check only 1, and the options are not guilty or guilty. In order to break up the closing arguments as little as possible, we're going to take our lunch recess a little early and start a little early with those closing arguments after you recess. So we'll go ahead and recess for your lunch break. If we could have everyone ready to go in the jury room at 12:45, please remember the admonition.
All rise for the jury.
Okay, everybody, there it is. We have the jury instructions. And from what I understand, the jury will go out of the courtroom. We are breaking for lunch. And then closing statements will start at 2:45 Arizona time. 12:45 Arizona time, which is 2:45 my time. I already have a link for that afternoon video here. If you would go ahead and go on over, if you go on over there and you click the button that says remind me, or whatever it is that the button says, I can't remember exactly. But if you click a button for a notification, then it will let you know as soon as I go live. Now, I am going to go ahead and go live at 3 p.m. Central Time, which is 15 minutes before the delayed broadcast starts. So 15 minutes before we are allowed to get the broadcast, I will go on and discuss some of the jury instructions that we just heard. And then we will start the feed again as soon as it comes through from Court TV or whoever has it first. And we will watch that feed together. We'll watch closing statements together, and then I'll have some comments after closing statements as well. So justice for Charles. My heart is with Kay and all of her relatives this morning. My heart is with Colby. My heart is with Kresha. I just pray for justice and for all of the family members to get the healing that they need in this process. So it feels very serious to me. It feels very heavy to me. Even though I'm not in the courtroom, that's really where my heart is right now. And so I'm going to go ahead and take a little bit of break. And as I said, I put the link in the chat there. My video is already up and ready to go for as soon as opening statements start. Again, we will be on a 30-minute delay. So, sorry, closing statements start at 12:45 Arizona time. That means the feed won't start until 1:15 Arizona time. And so I will start at 1 o'clock Arizona time, which would be 3 p.m. my time, Central Time, and with a little bit of commentary prior to the feed starting. And then we will watch it together, the closing statements and the jury going out for deliberation. So take a break, take some self-healing, self-care, get out into the sunshine, absorb some vitamin D, drink some water, check in with your loved ones, do everything that you need to do to take care of yourself in this process. And thank you for being here for me. It means a lot to me. I appreciate you. Please go ahead and click the notifications for that next stream, and I'll see you this afternoon. Take care, everybody.